The following BLTV program is brought to you by O'Flaherty Law. Please enjoy.
Welcome to Learn About Law. My name is Kevin O'Flaherty from O'Flaherty Law, and today we're going to answer the question, what is a guardianship for a disabled adult, specifically with a view towards Illinois law? So a guardianship proceeding is a court case in which the court appoints an individual to manage the personal and or financial affairs of an adult with disabilities who cannot manage those affairs for themselves, either because they don't understand them or can't communicate them. The court will appoint the type of guardian based on the needs of the disabled adult. So they often try to limit the guardianship to just the things that the disabled adult actually needs help with. A limited guardian is a guardian who can only make specific decisions that are explicitly stated in the court order. A plenary guardian can make all decisions related to the estate of the adult, so the finances, or the personal and healthcare affairs of the adult, or both. A temporary guardian is kind of what it sounds like. From the date of the filing of the petition to the date that the final guardianship order is entered, a temporary guardian is temporarily in charge of managing the affairs of the disabled adult. These guardianships only last for 60 days and expire at the end of that. They can be renewed by the court if necessary. Decisions about who will be named guardian are based on the best interests of the disabled adult. Let's now talk about the guardianship of the estate versus guardianship of the person. So there's two different types of guardianship, and this is within the realm of plenary guardianship, where someone makes all the types of decisions for a particular type of guardianship. But there are two different types, guardianship of the estate and guardianship of the person. A guardian of the estate manages the financial and legal affairs of the disabled adult. A guardian of the person manages healthcare and personal affairs, like who will have access to the disabled adult, where will the disabled adult live. They can be the same person or they can be two separate people. That's up to the court based on the best interest of the disabled adult. Now let's discuss when to file a guardianship. So when is it appropriate? When a loved one of yours is unable to understand the circumstances surrounding his or her financial, living, or health situation, or unable to communicate about them, that's when it can be very helpful to file a guardianship, because that's when you really need to have that power as a loved one to make those decisions or help that person make those decisions. The process of filing a guardianship is to, first file a petition to appoint a guardian in the appropriate court, usually the county where the disabled adult resides. You have to serve notice of the filing of that petition and of the prospective hearing date upon the disabled adult, family members, and there's a couple other parties that need to receive notice that your lawyer can help you out with. The notice, again, will include the date, time, and location of a hearing that will be held. At the hearing, the person seeking to be named guardian must prove first that the disabled adult is actually disabled and needs a guardianship, and second, that the person petitioning to be named guardian is appropriate to be named as the guardian. Basically, that's the best person to serve that role who is willing and able to do so. Usually a guardian ad litem will be appointed, and this is an attorney that is represented to investigate the best interests of the disabled adult, report back to the court on what those best interests are, and advocate for the best interests of the disabled adult. In order to prove that the disabled adult is in fact disabled, there will usually be a physician's report submitted from the disabled adult's physician that basically certifies that the disabled adult is not able to make certain types of decisions and the nature of their disability. Sometimes there will be dueling testimony from expert witnesses, so physicians or psychologists. If the disabled adult does not want the guardianship appointed over them, they can hire an expert to testify as to their well-being, and the person seeking the guardianship can hire an expert, and those testimonies will both be weighed by the court in determining whether the disabled adult is in fact disabled. So if you have any questions, you can leave them in the comments section below this post at learn-about-law.com or below the video on our YouTube station. If you found this helpful, please subscribe to us on YouTube, iTunes, and SoundCloud, and you'll be notified of our daily article and video topics that we post. If you need some help, give us a call at 630-324-6666. That's 630-324-6666. We offer free consultations in nearly every area of law, and we have offices all around Chicagoland for your convenience. Thank you so much for watching and listening.
Thanks so much for watching our video. If you have any questions, feel free to comment below. Click the subscribe button for new videos every week, and download and review us on iTunes. Visit learn-about-law.com for other legal-related articles and videos. Visit our business podcast and video blog, seizeyourbusiness.com, and visit Making Real Estate Fun for real estate videos and podcasts. Call us at 630-324-6666 for a free consultation.